mute. So everybody except the speakers, please put the microphones on mute. Otherwise, there will be a lot of background noise. Thank you. So the purpose of today's webinar is just to have a discussion amongst experienced lawyers and arbitrators, and those of you who have joined the panel of arbitrators on ADReS Now, as well as those of you who are interested as joining as arbitrators on ADReS Now and also want to use the facilities, to have a dialogue on the challenges arbitrators and lawyers have in terms of using many of the technology tools that are now available for arbitration. So the today's topic is very aptly said, unlearn and relearn. The idea is to see how we can adopt the new technology at the same time retain some of the core principles of arbitration. So broadly, that's the view. What are the lessons that we have that we can learn from the physical arbitration world, and make use of them in the online arbitration world? At the same time, to understand that online arbitration world doesn't mean merely replicating in a digital form whatever happens in the physical world. So how do we reconcile the advance of technology with some of the procedures that arbitrators and lawyers are used to in courts and in arbitration? And how do we make the most of the new tools that are available to us? So broadly, that's the theme. So today, I have two wonderful co-panelists, lawyers and arbitrators. First, Zubin Behramkamdin, who is a very experienced arbitrator and lawyer from Mumbai. Welcome, Zubin.
Hi. Thank you, Harish.
Second panelist is M.V. Sundararaman. Sundar is also an experienced lawyer and arbitrator. Also, Sundar and I have known each other for a long time. I know Sundar holds some strong views on the use of technology all the time for all processes in law. So it'll be interesting to hear his views.
Sundar, hi Harish. Hi Zubin.
Sundar has been a guiding force to ADReS Now team on many things as well. So welcome, Sundar. So what I will do is I'll first request Zubin and Sundar to maybe speak for about between 5 to 10 minutes. I'll let you choose the principles and the topics that you want to broadly cover. After that, I will spend maybe about 5 minutes talking, and then we can have a conversation amongst the three of us for another 10-15 minutes before we open the floor for any questions and comments that we have from the audience. So I will request Zubin to go first. Zubin, if you're okay with that, can I request you to
sure.
Yeah. So Zubin, all floor is yours. Yeah.
So okay, ODR is a very recent phenomenon. Of course, it's not so recent, but it's been brought into focus because of COVID-19, and now it's all the rage, or at least it's what we think we should be doing much more strongly. But the fact of the matter is that a lot of these principles and a lot of the reasons for ODR actually started long ago. And I myself started using a lot more technology about 4 years ago. And it started for very different reasons. It started because I just got tired of lugging around 4 to 5 bags full of briefs in large construction, especially international construction projects and in arbitrations. I just could not manage 5 large bags with the tunes or whatever. And it just became too cumbersome. And I thought to myself that there is something I have to do about this. And now that we have this technology and we have our computers and we have our iPads, we just have to, somehow I have to shift onto that and make things more sensible rather than going around like this. And that believe it or not, is how I started using technology. And it started, of course, just by putting all your briefs onto the iPad. So you didn't have to carry around so many hard copies with you. But from there, it, of course, progressed. And once I started using the iPad, it became much easier. And every part of what we used to previously do the long way, or by maybe a physical books, etc., started shifting onto the computer. And that's how ODR slowly we started getting into. So your research, as you now know, we rarely look up books. I mean, you can read a good book or you can read a good commentary book, of course, because there's nothing like that, as I tell my juniors. Nothing better than that, rather than just trying to look up case law based on some words. You get a history of the law from a commentary book. But still, by and large, today, if you have to look up some case law, you will still go to your computer. You're not going to go to your library and start pulling out books one by one. So as far as the research is concerned, we had already shifted to the digital. As far as your briefs are concerned, we had shifted to the digital now with different kinds of softwares which we have for actually annotating and for sorting out your documents, etc. It has become very easy. Your search has become very easy. And so you have shifted your research, you've shifted your pleadings, your documents, everything onto the digital. The use of online dispute resolution was, of course, restricted before COVID because we never really felt the need to shift. That's the truth of it. We normally change only when we require to change or when we are forced to change. And we are so used to just meeting physically that we really didn't, though we had the technology, we never thought of changing. So ODR was used, of course, you had your video conferencing, etc., but you used it only when maybe a witness could not travel from abroad, somebody was ill, or there were constraints of time, there were constraints of cost. And those are the times we used to use ODR, even in our old-fashioned arbitrations. And that is when we had to take a special order from the arbitrator or the judge to say, okay, I want this done on commission. Please allow me to now hold this on video conference, this particular meeting or this particular cross-examination. And that's what we used to do in the old days. But now we find that that kind of a thing has almost become what was a luxury then or what was an unusual circumstance then has now become the norm for today. And the more we start using this, of course, we realize that in day-to-day matters also and in everyday matters also, there are many advantages to this system which were not there in the old system. So one obviously is you save a lot of time. There is no time taken for traveling around the place. Everyone from wherever they are seated can just join the arbitration whenever it's taking place. The other is, of course, convenience. You don't need to travel around. Now, forget about traveling from city to city or even from country to country. In a city like Bombay, and I believe Bangalore too now, the traffic is just so terrible that someone is coming from the suburbs. It's almost like as if they're traveling down from somewhere out of town. It takes them 2-3 hours at a time sometimes. So you save that time of travel, etc. And you find that online arbitrations, therefore, are much more convenient, even when you're just doing a local arbitration, which you had earlier never thought of doing as an online dispute resolution or as an online arbitration. So there are many advantages to it. There are, of course, the countless advantages when it really comes down to document management, when it comes down to actually working with your documents, etc. The exchange of documents online is very easy. You have many platforms now, whether it is Google Drive or OneDrive or any of those other platforms, or there are even those specialized platforms where you can store all your documents. Everybody, once it is stored there, everyone has access to it at the same time. Just compare this to your old-fashioned method where you would take some documents, you would make sufficient copies, you would make a forwarding letter, and you would physically send someone with all those copies and the forwarding letter, and then you would say, okay, I have served somebody. And all that is put aside when you just upload all your documents onto one of these drives and everyone can access it at the same time. So there are any number of advantages. And frankly, we would have gone down this path without COVID-19 too. It's just that we would have gone down this path much more slowly. Now, having said that, I must say that even today, so wherever I am a arbitrator in ad hoc arbitrations, and especially where I am the sole arbitrator, I have managed to convince almost all the parties who are before me to now start their arbitrations online or to shift their arbitrations online. This is not an easy job. It was not an easy job. You will often find that the respondent or the defendant, whoever doesn't have much of a case or who doesn't have a counterclaim, is only too happy to delay. And these are the people who are the last to jump on the bandwagon and are the last to agree to an online dispute resolution. But I'm happy to say, if you handle the matter with some amount of tact and some amount of understanding, I have managed to get all of them on board. Some have come on board faster than others, but they have all come on board, and online arbitrations in all my matters have started today. So that is a good development. I think it's an encouraging development, and that shows that people everywhere, whether they are advocates or they are parties, have kind of realized that this is the way we are going to move forward now, and it's become some kind of a necessity actually in today's day and age. Do I have some more time, Harish, or your mic is off?
No, happy for you to take a few more minutes, no problem.
Okay, sure. So the next thing which I would like to get into is some of my experiences as far as the online arbitrations are concerned, and what we have actually seen, some personal difficulties, etc. What I have found when I started these. So ODR, online dispute resolutions, actually, though they are convenient, because the whole system is a little new to us, and because we still do not have, especially in ad hoc arbitrations, it is very new because, I mean, everything is different. You may decide on a certain platform, you may decide on a certain procedure for putting your documents on record, you may decide on certain procedures for cross-examination, and all these procedures are not, they have not been set out earlier, unlike in maybe an institutionalized arbitration where very often these procedures they have already decided upon. So they will already have decided about a platform, for example, and there is no question of asking advocates and asking parties and taking their consent and then deciding on a platform. Similarly, for posting documents, etc. online, there will already be some system, there will be some drive, they may have their own, many of these institutionalized arbitrations have their own systems for putting documents on record, etc. And therefore that system is followed, unlike an ad hoc arbitration of ours where we would have to say, okay, come on, let's decide on this. Should we put it on Google Drive? What should we do, etc. So these are the things which take a little bit of time, but I find that people are moving ahead by consensus. It's a very good development. And by and large, I haven't had too many problems. While actually doing these arbitrations, I do find that some bits are more tricky than others. So making simple arguments, whether it's a Section 16 application or a Section 17 application, is maybe a little easier than when you're actually doing a cross-examination online. That has a few twists and turns to it, which we need to take care of. So you need to, of course, the first one being just security, and the party who's cross-examining wants to know that the witness is actually alone, that the witness cannot be assisted in any way, and that they are secure that he is the only person answering. And there are many techniques which you can use to ensure things like that. One is, of course, you ensure that the witness is in a separate room, nobody else is in the room. The second is you ensure that he is covered by more than just one camera. The third is you ensure that the camera covers his table, his laptop, and his papers, so that he is not, he doesn't have anything else with him which he is really looking at. And of course, then you have these different platforms where you can do different things. So you have to use the pinning of the witness, the pin procedure or method which is there. It's there in most of these softwares, where if you pin the witness, the camera doesn't leave his face, even if he is not talking. Otherwise, in some of these platforms, as you are aware, the camera only goes to the face of the person who is speaking. And sometimes, therefore, the witness may be lost sight of. But the easy way to solve that problem is you must pin the witness, especially the party who is cross-examining the witness, so that they can ensure he is within their sight at all times and they know what he has been doing. So there are these kind of procedures also. I am sure situations will arise which we have never thought of. Problems may still arise. So I had a very strange and funny incident in one of my arbitrations where the side was cross-examining, the advocate didn't know her mic was on, and she said, I'm going to pin the witness, she told her husband. And the other side started shouting, see, they said they are going to ping the witness, P-I-N-G. That means they're going to warn the witness. Then we had to look at the recording and we had to sort it out. And I said, no, there was no question of pinging the witness. And this had really not happened. In any event, I think assisting the witness by pinging him or giving him this kind of a small assistance really doesn't work. It's really impractical in the sense that if he's a witness of fact in his answering complex questions on a construction contract and what happened and when it happened and etc., you really can't assist much by just pinging the witness once in a blue moon. But that's besides the point. I appreciate the fact that one has to take whatever precautions one can take. And this is the way in which I have been moving forward with my arbitrations. And I find that it is not bad. A lot of it is common sense. Some of it will be trial and error because these are new techniques. And because we are not using when you are using an institutional arbitration, of course, things are much easier because, as I said, the institution has already streamlined the procedures. And therefore, even when ADReS Now has started its procedures, I find a lot of things have already been streamlined. So unlike an ad hoc arbitration, the arbitrator and the parties don't have to struggle around to find a platform and to find what exact software they will use and the procedures that they will use further on. And this has been my experience, but on the whole, it has been a very positive experience. And I'm sure we are going to have to move forward like this in the future, COVID or no COVID. Okay, Harish.
Thank you, Zubin. Very, very relevant points. I have a few questions, but I'll wait until after Sundar has made his opening remarks. Sundar?
Yeah. See, maybe in the 90s when we started practice, the catchword was ADR then. That was the time when the new Arbitration Conciliation Act had come into force. And everybody was talking of arbitration, conciliation, and mediation, and it was all fancy for us to talk about ADR then. Now, maybe it's almost nearly 25 years later, we are talking of ODR. Definitely, there has been a march, and I think ODR is definitely a new concept that is catching on, and everybody is talking about it. Now, having said that, ODR is technology, and is technology new to us in arbitration is what I asked myself. See, we've been using technology all these years, and arbitrators themselves have been using technology maybe in the past whole decade. We have been using emails for exchange of documents, for scheduling meetings, for exchanging interrogatories, for several purposes. So technology and use of internet, I feel is not new at all to arbitration. Now, what is the progress that we have made from just emails and faxes to ODR today is maybe this additional concept of having video conferencing and recording of witness testimonies and syncing all that and calling it ODR. So it is nothing new. So what ODR does is merely an extension of what we've already been doing till today. Cumbersome process which was taking months together, maybe take a few weeks now, and that is definitely progress. Now, having said that, relearning and unlearning, there's a lot for us to do, especially for us who have been sitting before arbitrators for months, who've been standing in court for months, and if we have to sit down in front of our laptops and finish maybe an arbitration in a few days, there's lots of unlearning for us to do. So there needs to be a fundamental change in our mindset is what I think. Instead of thinking of dispute resolution as relatable to a place, that is we need to go to court or we need to go to an arbitral tribunal sitting in a building, we need to think of it as a service that's readily available for us in a platform that if there is a dispute, we should start thinking or, educating ourselves that, this is a service that is readily available. We can go there and this is a dispute that's going to be resolved in a given easy procedure. And that's how we need to I feel that we need to realign and rewire ourselves to think that ODR is a service, and it is not. It is not something that is new, or that is that's a ghost that's going to haunt us, or which is completely inaccessible to us. And also, what I feel is ODR itself is not just an expression, and it's a whole process. ODR, it can be broken down into several bits, and the amount of flexibility it can offer in terms of an arbitration, in fact, thinking about it itself is immense. Ideally, we can decide, to what extent technology can be used in arbitration, whether the entire arbitration can be put into a technology process, or whether a portion of it can be put into a technology process. The option is with us, and to that extent, I feel there is so much flexibility in an ODR process, which definitely merits exploration, and we need to actually start thinking like that. And until we start thinking that this is a process that's going to help us, I don't think we can realign ourselves. And also, I feel in any dispute resolution process, what is the bottom line? The bottom line is that even if it's an online platform, if that platform is going to offer equality to both parties, if it is going to offer you a fair arbitrator, if there is going to be a fairness, if the platform is ensuring fairness in the arbitrator's treatment of both parties, and if that platform is a user-friendly, intuitive platform, I think half the job is done. And that is what we need to ask ourselves, if we are going to embrace ODR as the successor to our traditional arbitrations. And if there is a yes to even two of these, I would say we should go ahead and plunge into ODRs, because ODRs is the way forward for everybody. And as Zubin was telling us, this tremendous power in ODR, when I keep all the processes which we normally do in a traditional arbitration, and if I broadly see there are two steps. One is the regular procedural steps, and the other one is, of course, the substantive steps. In the procedural steps, almost every aspect in the procedural steps in an arbitration, starting from service of notice of arbitration, in terms of the preliminary hearing, case management, exchange of red phone schedules, in terms of exchange of interrogatories, in terms of settlement of issues, I think parties' presence sitting together at any place is not required at all. I think this could have been done even in our traditional arbitrations, where most arbitrators, I feel, in my experience, are loath to do that, because they would want a hearing even to settle issues. They'll say we need parties to be present. Now ODR is here, and it kind of filters away all those steps where you don't have to meet each other. Even a preliminary hearing can be done over a VC today, and parties don't have to be present at all. And then if we go to the substantive steps, in substantive steps, I see that conduct of trial, maybe interlocutory hearings, and a final hearing. This may require party interaction, as in we need to see each other. It's essential for that. And this is where ODR makes a great change in our lives. As Zubin said, and as we all know, that we can do it sitting wherever we want to. And to this, I've heard lawyers complain, and maybe even I used to complain some time back, that you need to actually stand in front of the witness, and you need to look into the witness's eye, and that's when a cross-examination is effective. And the other grouse which I've heard from lawyers, that why ODR may not be effective in recording witness testimonies is the demeanor of the witness. Can't be understood by the arbitrator, and the arbitrator has to see the body language of the witness. So my response to all this is that all this is, these negatives are all overstated. We are talking of commercial arbitrations. Let us accept that ODR for today, at least where we are looking at it today, will be used mainly for commercial disputes. And in commercial disputes, as I think most of my friends who are here today and most lawyers will agree, that in a commercial dispute, I will say in a regular construction contract dispute, how many times have we in our experience seen arbitrators recording demeanor of witnesses? In my experience, I've never seen an arbitrator recording demeanor of a witness. To that extent, even in a civil dispute, in a civil court, it is in the rarest of rare cases, I can't even recall when a judge last recorded the demeanor of a witness. These are all nice things to hear and talk, but these are not practical things which actually happen in trial. So coming back to our relearning and unlearning, we need to kind of erase these words from our mind to say that, do we have to actually know the demeanor of a witness in a construction contract? Not essential. Do I have to look into the eyes of a witness in a construction contract? Not required. Having said that, and also I have seen in my experience that in commercial contracts and in a commercial arbitration, oral testimonies are of least importance, and in most probabilities, the entire arbitration is decided on records and based on correspondence that has expired between exchanged between the parties, and also what is stated in the contract. So lawyers who have always complained, disputants who have always complained that you can't see a witness, you can't understand his demeanor, etc., are all negatives which don't have to be stated today, and those are all archaic according to me. If we have to move forward, we'll have to keep those aspects aside and continue. Of course, having said that, every new system that we have to embrace, there are going to be issues. There is going to be resistance, and it's human to don't overcome that, we are not going to progress. That is my view insofar as this grievance is concerned. The other grievance which I recently noticed was when the bar conferencing facility. So this could be a similar complaint when we are talking of ODR to say, is it accessible to everybody? That is another question which is frequently asked, to say that, is this only the domain of people who are sitting in cities or people who are sitting in fancy law firms? So my answer to that is actually no, it's not correct. If you see, in my view, that everybody any lawyer, any disputant who's from a tier 1, tier 2 city has a mobile phone, has a smartphone, he has access to internet. And I can't think of anybody who has no access to internet today, especially in a tier 1, tier 2 city. I asked them, do you use WhatsApp? Do they have a Facebook account? The answer invariably is yes. If they have all that, it is obvious that they might have.
Looks like we have lost Sundar.
Yes.
So while we wait for Sundar to rejoin, actually, the difficulty with being the host and putting myself as a last speaker is I don't have anything left to add to what Zubin and Sundar have said. I think they made fantastic points and addressed most of the questions I had in mind. What I would like to do is instead take this opportunity to explain the thought process about the enormous opportunity that ODR has in India. All we need to do is, and most of us on this call are lawyers, arbitrators, all we need to do is look at the number of civil disputes that arise in this country. Normally, they are in the range of about 50 to 60 lakhs a year. If you look at just the country, just civil disputes in subordinate courts. And the average time that takes, in this country to resolve any civil dispute at the first instance is about 5 years. This is the average. In some places it's 3 years, in some places it's 8 years, in some places 10 years. Now, potentially, ODR can unlock the clogged courts and let courts, focus on criminal disputes and rights of citizens by taking away the pure commercial cases into arbitration. And so Just to give you the, if you wanted to, replicate the ODR world in the physical world, you would need to establish about 20,000 arbitration centers across the country. That's the number we are talking about. So for a country like India, this is almost a necessity. And even when we started conceptualizing ADReS Now, we started doing it about a year ago when we were not visionaries enough to recognize that COVID may come. Unfortunately, that I think we would have stopped the ODR platform and got into medical services or something like that, right? But I think COVID has presented us an opportunity to accelerate the process, to move arbitration online. So only Sundar has joined us back, so I'll let him complete. I want to make 2 points. One, we need to look at this as an opportunity to solve disputes, and both from a professional satisfaction point of view, plus solving the client's problem. And I think this is an enormous opportunity. And as long as we adhere to the basic principles that our legal system promises, like principles of natural justice, fairness, integrity, no bias of the arbitrator, things that we hold dear from the legal system's perspective, then we should not be raising unnecessary objections like, I'm not used to this. Will it work? Will it be enforceable? All sorts of questions which to some extent have been rendered irrelevant because of COVID, because the courts have started using the virtual system. So they're not going to reject an arbitration award only because it was, video hearing happened by video conference. That is out of the question now. Maybe 3 months ago, if somebody had asked me, maybe there is a doubt. But now every court is doing video conferencing. So they're not going to reject your arbitral award because, the hearing happened by video conference or notice was served by email. All these are now questions that are irrelevant because these are now part of our vocabulary. And hey, even our grandmothers have started using WhatsApp calls to see their grandchildren. So I think to say that, all this technology is new, I think is a bit of a, is an exaggeration. So while we need to adopt the new, I don't think we should adopt technology for technology's sake. We should see what is it doing for us? What is it doing for lawyers? What is it doing for arbitrators? What is it doing for clients? And I think while, as both Sundar and Zubin mentioned, there will be mistakes that will happen. There will be problems that will arise. But we need not be fearful of it. We need to look at them and try to overcome. So I'll stop there. Sundar, you want to take a minute and complete what the thought that you're making, and then we'll take some questions.
Yeah, sorry, I got cut off. I just had 2 more points to make. I was just thinking of what advantages ODR has for us vis-a-vis the traditional system that we have. I can only think of positives. Today we are like saddled with retired judges only as arbitrators. Today, if you ask me to suggest an arbitrator for a dispute, the first name that will come to my mind is a retired judge. It's the last thing I'll think of is maybe an engineer or an architect or a lawyer who is specialized in that. But with ODR, the access to specialist arbitrators has increased, I would say, manifold, because you can access or you can get in touch with an arbitrator who's sitting in any geography today. If he's an expert in the area of your dispute, the answer is almost yes, because these arbitrators today are willing. You don't have to worry about whether he has knowledge in the area of your dispute, or whether he would be willing, or whether what would be the cost, etc. ODR kind of negates all that and gives you almost ready access to an expert arbitrator, and we don't have to be saddled by the existing traditional method of going only to a retired judge. That is one of the greatest positives, I think, which ODR offers. And the second point which I wanted to make was, people complain that if you're in an ODR platform, there'll be myriad questions relating to jurisdiction that will arise, and these definitely will arise and be grounds in a Section 34 challenge. That also, I think, is completely unfounded, because the moment you submit yourself to an ODR platform, you're obviously going to sign a contract, and that contract is going to tell or state in so many words what is the seat of that arbitration. If that is done, it does not matter. Your ODR platform is only a place or the venue of arbitration. You could be sitting anywhere. You could be sitting in your house. You could be sitting in a club, wherever, so long as your contract recites which is going to be the seat of arbitration, the job's done. So these apprehensions which are coming out may be founded because ODR is new. It is for us practitioners to actually take ODR forward and make it maybe a word which lawyers would use, a platform which everybody would use, and it should become the next ADR for everybody is what I think. And there is a lot of unlearning to do, but I think lawyers are capable of that, because from the 1940 Arbitration Act, we came to a 1996 Arbitration Act, which is almost 50 years later. And from the 1996 Arbitration Act to probably regulate ODR, I think the march is not far away. It's very close by. Harish.
Thank you, Sundar, for those excellent points. Keshwa is managing the questions. So Keshwa, do you have any questions?
Harish, Abhirup is managing the questions. I'll get back to you on that. I'll check with Abhirup and get back. Sure.
Okay. But while we are waiting for the questions to come out, let me ask, both Zubin and Sundar, can you, if you were to unlearn one or two habits from the physical world to suit the ODR world, what would those be? Unlearn and relearn. Okay, 2 habits. Sorry to put you on the spot, but I think this will be interesting for our, audience. Yeah.
I don't know, Harish. Actually, I'll tell you why. Because besides the fact that I didn't like lugging around those huge briefs, I was always interested in technology. I love my phones, my tablets, etc. And therefore, to find a new way of doing something, etc., was always it was exciting for me. So it was something I looked forward to.
Okay.
So I find it. So it's not easy for me to answer your question, because I can't think of one thing which I would hate to change. But okay, so I'll tell you one thing which I don't think is so great, especially in India. I don't think this live transcription is such a great thing, and I'll tell you why. I still prefer the traditional method, even if it's an ODR, where the arbitrator was to dictate the final question and answer, or at least would step in when there is some uncertainty in the question and answer. Now, this happens, I think, to a great extent because English is not our first language. And I say that for the best of us. We may think our English is great, but it is not. And I often find that because of that, if you were to just leave and you actually have something like a live transcription and you get a question as it is asked and an answer as it is given, you sometimes end up with quite a lot of gibberish. And you can see this, I've had live transcriptions of some of my arbitrations, and you will just see page after page. I mean, one question and answer will sometimes take page after page because you'll have someone coughing, someone saying something else, the questioner asking the question and then explaining the question sometimes 2 or 3 times, because that's what some counsel do. And then the fellow answering and then correcting himself another 10 times. And therefore, I think that, okay, something like live transcription, either it's not that great. I don't find it that great an effective tool in our arbitrations so far, but I'm sure it will also catch up and we will learn how to use it more effectively. But as of now, I don't think we have learned how to use live transcription very effectively. So that's one thing which I'm not so happy with, to answer your question. But once again, I think it is something which we have to improve on, really. It's not the technique which there's something wrong with.
Yeah, Sundar?
Yeah, 2 things that come to mind is as a regular trial court lawyer, what I would say is I would first think of filing lesser documents, because we are used to filing every scrap of paper that we have. If it's a construction contract, we think our document filing should be as big as the construction itself. That is the first thing which I want to unlearn, is that we should file documents which are only necessary, because ultimately when you see the award, it is not that the arbitrator or the tribunal is going to look into every email that you have filed. The arbitrator is going to only look into the most important documents. So the first learning that we have to do, or I would say unlearning that we have to do, is stop filing every document or every correspondence that was there between the parties, and try to make your filings as lean as possible. Because if the filings are not lean, then the ODR becomes extremely document intensive, and that is when the process becomes cumbersome. So the first step is to not file all documents that you have, and use your discretion and file as little as possible, so that the process becomes easy. And second is to stop filing verbose pleadings, because it is our want that we want to tell everything that happened the day one when I met him for coffee before we signed the contract, till we actually punched each other on the face when we terminated the contract. We want to say everything in our pleadings. So that is another thing that we must unlearn, and keep our pleadings as lean as possible, because that is when actually the issues can be discerned. If pleadings are verbose, the issues get lost. That is my experience. So that is another unlearning that we need to do, because this is a golden opportunity for us to actually set new trends, set new precedents in place. So these are two things which come to mind, and that is insofar as filings are concerned. And insofar as the conduct of arbitration itself is, I would say that we should learn to keep our cross-examination crisp. Because I myself have cross-examined witnesses for no reason for 3-4 days together in an arbitration, tired myself out, tired the tribunal out, and everybody out, and then everyone's fed up. So in an ODR, obviously, when you're staring at a screen, the possibility to do something for 3-4 days together will not arise. So it intuitively you're going to reduce your cross-examination, and we will only ask what is more relevant. I'm sure Zubin knows, and he would have suffered tons of cross-examination like this. So we should learn to conduct our trial as quickly as possible and keep it as lean as possible. So these are two things which come to mind when in the conduct of the actual arbitration itself. Harish.
Great. I think again, very, very important points, and I'm wondering, while Sundar, I think, is basically giving a message to all of us lawyers in the guise of using ODR as an excuse. He's basically telling us all to get our act together, even in general proceedings. But I think fair points, excellent points, both Zubin and Sundar. There's one question from a participant. And I think this is somewhat linked to what Zubin was talking about, transcription and all of that. So are arbitration proceedings recorded so that the arbitrator can refresh his memory after going through the documentary evidence, pleadings, etc., prior to passing an award? I don't know about other ODR platforms and what everybody does. I think many people do, but at ADReS Now, every recording every proceeding is recorded. Is video recorded, and the recording is made available to all the parties who participated in that proceeding within a few minutes of the hearing being completed. So we debated a lot about this transcription issue also, and demeanor, and whether in India also, particularly if they are retired judges who are the arbitrators, they then paraphrase the what the witness says into some neat language which how they want to remember. So there's a lot of cumbersome thing, and this is one of the points on which I have a lot of arguments with different arbitrators and lawyers when they first ask me, do you have transcription, do you have simultaneous typing, do you have all of this? And I keep telling, listen, I know you are asking me all this because that's what you are used to in the real world, and this is the point I want to make, is that you don't need to necessarily transpose. You should ask, okay, why are we doing that? Okay, because in the real world, to record the the witnesses cross-examination and statement, there was a necessary procedure. When you are able to to video record the whole cross-examination, why do you need transcription as well? I think somehow, I know I'm asking a very, very confrontational question, but I think it's something we need to think about. Yes, we are used to transcription as a particular way, but when you're recording the whole thing, when the whole entire 1 hour or 2 hours or 4 days in Sundar's case, cross-examination, we can record the whole proceeding. What's the problem? And I think now I'm sure technology will develop where you can actually search words in the person's cross-examination, in the person's what he's saying. You can actually search for keywords and come to the relevant point. So I think these are some of the things that we can look at. So I think there's one more question. I think meanwhile, while I'm looking at the question, if Sundar or Zubin wants to add something to that, please do.
This is, excuse me, Harish,
yes.
This is Karthik.
Yes, Karthik.
I was thinking that though we usually accept questions by chat and WhatsApp, if some of our distinguished guests want to ask questions on the phone, on the using the microphone, I think they can do that as well.
Sure, we can. Yeah, we can allow that. Let me first ask the question that has come in. The question, and I think any of us can answer. What is the maintenance of confidentiality during a ODR? Do third parties have access, security of information, and all of that? I think this is the same. As I said, there are two parts to my answer, and Zubin and Sundar can comment later on. I feel that you're now looking at industries like, say, banks, where confidentiality and sensitiveness of information is so high. Even those industries are moving to digital and online means. So I don't think there is a problem with maintaining confidentiality, as long as ODR providers put in place enough systems to maintain confidentiality. There is no issue. Now, if somebody is intent on not maintaining confidentiality, there is a problem. But again, before I stop my comments, I can only say that at ADReS Now, each hearing or each arbitration is only open to the parties and their lawyers and the arbitrator. So whoever they let in has access. If they don't want to let in somebody else, they can kick out. So that's the procedure that we have adopted. But Zubin and Sundar, you want to add anything on confidentiality?
Yes, no, I agree with Harish. The difference is only this. When you have, as I said, when you have an institutional arbitration or a platform like ADReS Now, they will already have put in place certain procedures for the security, etc., like he mentioned. When you have an ad hoc arbitration, the difference is that you meaning if you are the arbitrator, you just have to make sure that these procedures are also put in place. So in my ad hoc arbitrations, we do have these procedures in place. So you have to ensure that the invite is sent to only the parties and their representatives. It's not, you have to make sure your passwords are in place, and you have to make sure that somebody else can't get into the meeting. So your security has to be okay. If you have security concerns like with Zoom, etc., you have to make sure you're using the right platform. You have to make sure there's end-to-end encryption, and that kind of things which you have to look at. But once you look at those things, I think, as Harish says, it's as safe as anything else. As far as your documents, etc., are concerned, also, you will normally put them up on some drive, like I said earlier, also. And you have to just make sure that the drive is not only secure, but also that access is given only to those persons who are entitled to it. And very often, in fact, before an arbitration starts, parties enter into confidentiality agreements and give declarations, etc., and undertakings that they will on confidentiality and that they will not be misusing the information that is there in the arbitration. So that's another thing that can be done. So these are all procedures which have to be taken. And once they are taken, I think there's no issue on security either. And these have to be taken. Sundar?
Yeah. Sundar, you have...
Yeah. No, just to add with what Zubin says, see, this apprehension about confidentiality, according to me, is founded. And as I said earlier, that before you submit to any ODR platform, only questions we need to ask ourselves is, am I going to get a fair deal out of this? And that, I would say, would include questions in relation to confidentiality. If the platform assures you, and if the platform is experienced enough, and also if the software is so mature that it is promising you and assuring you confidentiality, and then I would go for that ODR system. And as I said earlier, that this is a system that has to develop, and people will have to believe in it. And once it starts working, then there is no going back in this. That is my view.
Okay, there's another question. Please explain something more on pinning a witness and other measures that you can adopt to ensure fairness in witness testimony.
Okay, so the tool of pinning the witness is there in many of your platforms, like MS Teams, for example, where I was using it. Is there on MS Teams, but I think it's there on almost all the platforms. There are 5 or 6 platforms which you can pin this. So there is an option which you get, and which says pin the witness. And when you click on that option, as I mentioned, that person stays on your screen. He stays on your screen irrespective of whether he's speaking or not, and irrespective of the other people who may come and go on your screen, because your screen may not be able to accommodate, depending on your platform, it may not be able to accommodate all the parties who are participating, or all the parties on that call or on that platform. So, but once you pin that particular person, that person's image is always on your screen and you can see him at all times. That's all that pinning really means. And as I said, I think many of them have this. Other methods, as I mentioned earlier, was only that you have to ensure that the witness is in a room by himself. Nobody else is with him. And one of the easiest ways, or only ways, of ensuring that probably is to have more than just one camera. So you have a view of the entire room. That, of course, is a little tricky and a little cumbersome, but in time, I'm sure we will get used to doing that also. The third thing you can do, of course, is to ensure that the camera, or at least one of the cameras, either it's placed a little distance away, or it's so placed that you can see what the witness has on his table, whether he has a computer, whether he has books, papers, and what those papers and books are, what he is referring to. So these are the few measures that one can use to ensure that the witness is not being coached. Of course, there is the time-honored and old tested method, which is, of course, it's only not usable in COVID times, but otherwise the old method was that you depute someone, the other side deputes one person to sit in the same room as that witness to make sure that he is answering properly. And that can still be used. You can always have a person who is in the area, or a local person sitting there with that witness. So that can always be done.
Sundar, would you like to add anything to that?
Yeah, this concept of cross-examination via teleconferences has been happening for quite some time now. So other than the physical safeguards, as Zubin was saying, I remember that in 2002, there was a Karnataka High Court judgment where for the first time it sanctioned cross-examination of witness who's sitting overseas by teleconference. So there was a slew of instructions which the Karnataka High Court gave, including what Zubin is saying, that you could keep somebody in the witness room or keep 3 or 4 cameras, get the witness to stand up and show the room to the other party. So these are things which is there in the form of a judgment. Maybe I'll share that judgment after the call. It's interesting. Maybe if all this can be loaded into rules, or as procedure when the arbitrator is going to start the arbitration, it would be good, and so that nobody has any doubts as to what the witness is saying, or the witness is shamming, or somebody is standing behind the screen and prompting him or giving him chits. So all this can be ensured. But as I said, these happen the rarest of rare cases. So these minor aspects shouldn't deter the process itself. We shouldn't fear a process because there could be some hitch somewhere. That happens even in an arbitration, because there's another arbitration which we were doing recently where after 3 hours of recording cross-examination, the system crashed. So we had to actually have an action replay the next day because we couldn't retrieve anything. So I ended up asking the same questions, and the judges and the arbitrators were watching whether this witness would change his answer, because at least it was fresh in everybody's mind. So the witness. So if we are talking of bugs in the system, yes, there will be bugs in every system. We need to overcome that. And that, as Zubin rightly said, is over time. It can't happen today. And because we fear bugs, we shouldn't stop ourselves from entering new territory.
Okay, I would like to just give an example. I think after this COVID started, I don't know how many of you followed, there was a chess competition, international chess competition, India, Russia, US, China, and it was all online. And one of them, and chess, as you know, it's easy to get help. All you need is another computer, because apparently supercomputers can think even faster, and so they can predict moves. So they had rules on where the player had to sit, where the computer was, and how much space, and the computer had to be placed such a way that the entire table and the room would be visible. So to ensure that there is no cheating. That's all. But another point I would like to make is, and this is a point that I think Sundar and even Zubin, both of them made earlier, is that in commercial cases, now most of it is document. Right?
Yes.
It's very rare that something comes out in cross-examination. At best, at least in my limited experience, what I've seen come out in cross-examination is the link maybe between one document and another document which we were not able to see, or somebody was denying, or so it's very rare that something surprising comes out and that changes the case in an instant. So I think so. We should also remember that. So we'll keep that in mind. I think we are close to 6 o'clock. What I will do is I'll ask Sundar first if you want to give us any closing comments, and then come to Zubin later.
Yeah. In my view, ODR is going to be the order of the day soon, especially now that we have seen COVID. Now that lawyers are more or less used to video conferencing, and video conferencing has become part of our lives, not just for emergent matters. We've had meetings with clients on call, on video conferencing. We are exchanging documents already. We are doing filings in the High Court also by email. So I think ODR is going to be the order of the day. So sooner or later, we need to start unlearning what we have learned traditionally in traditional arbitrations and think of online as going to be our way of life. And as I said earlier, there's no harm in ODR. ODR is just a name given to an entire process. It's for us to choose which part we want to accept and which we don't want, and which part we need to develop. I can see only positives in ODR, and the negatives are clearly overstated.
Zubin?
Yes. So I too feel that ODR today, of course, is some kind of a necessity. But it's here to stay now. Even if, let's presume, COVID is to disappear forever next month, I don't think ODR is going to disappear. There are just too many advantages. We were already on the path, but we were trudging along too slowly. And now we will be pushed along a little faster. There will be tremendous saving of time. There will be saving of expense. There will be saving of travel. And the advantages are just far too many. So even if we do things improve and we kind of go back sometime to some extent to our physical hearings and our geographical locations, etc., ODR is here to stay. And you may have some kind of a hybrid system sometimes, or you may have certain matters or certain parts of a matter in which you would want to have your physical hearings, etc. But on the whole, ODR is here to stay for a very, very long time. And I think things will be moving towards that in the majority of the cases.
Thank you. I think we should end on that note. Thank you, Sundar and Zubin, for being wonderful panelists, and
thank you very
for
much.
giving us a lot of insights.
Thank you, Harish.
Thank you very much.
Harish, for the invite. Thanks a lot.
Thank you. Thanks, Zubin. Bye.
Bye.